Ready? ASTC classes. Exercise 296. Start. The code may interfere at section 8 or 11 stage when it is manifestly and ex facie certain that quote, the arbitration agreement is non-existent, comma, invalid, or the disputes are non-arbitrable, comma, though the nature and facet of non-arbitrability would to some extent determine the level and nature of judicial scrutiny, full stop. It is further observed that the restricted and limited review is to check and protect parties from being forced to arbitrate when the matter is demonstrably quote, non-arbitrable and to cut off the dead wood unquote, full stop. It is further observed that the prima facie review at the reference stage is to cut the dead wood and trim off the side branches in straightforward cases where dismissal is barefaced and pellucid, and when on the facts and law the litigation must stop at the first stage, full stop para. Applying the law laid down by this court in the aforesaid decisions and considering clauses 36 and 37 of the agreement, and when a specific plea was taken that the dispute falls within clause 36 and not under clause 37, and therefore the dispute is not arbitrable, comma, the High Court was at least required to hold a primary inquiry, review, and prima facie come to conclusion on whether the dispute falls under clause 36 or not, and whether the dispute is arbitrable or not, full stop. Without holding such primary inquiry, and despite having observed that a party does have a right to seek enforcement of agreement before the court of law, as per clause 36, thereafter has appointed the arbitrators by solely observing that the same does not bar settlement of disputes through Arbitration and Conciliation Act 1996, full stop para. However, the High Court has not appreciated and considered the fact that in case of dispute as mentioned in clauses 3, 6 and 9 for enforcement of the agreement, the dispute is not arbitrable at all, full stop. In that view of the matter, the impugned judgment and order passed by the High Court appointing the arbitrators is unsustainable, and the same deserves to be quashed and set aside, full stop. However, at the same time, as the High Court has not held any preliminary inquiry on whether the dispute is arbitrable or not, and or whether the dispute falls under clause 36 or not, we deem it proper to remit the matter to the High Court to hold a preliminary inquiry on the aforesaid in light of the observations made by this court in the case of Vidya Drolia within bracket Supra, and in the case of Indian Oil Corporation Limited within bracket Supra, and the observations made herein above, and thereafter, pass an appropriate order, full stop para. In view of the above and for the reasons stated above, the present appeal succeeds, full stop. The impugned judgment and order passed by the High Court appointing the arbitrators in terms of clause 37 of the addendum agreement dated 19/4/2011 is hereby quashed and set aside, full stop. The matter is remitted to the High Court to decide the application under section 11 within bracket 5 and within bracket 6 of the Arbitration Act afresh, and to pass an appropriate order after holding a preliminary inquiry, review on whether the dispute is arbitrable or not, and or whether the dispute falls within clause 36 of the addendum agreement or not, full stop. The present appeal is accordingly allowed, full stop, no cause, full stop. Thank you.
Please like and subscribe the video.